The moment you are in e-retail, you are providing your services on computers, computer systems, computer networks, computer resources, and even these kinds of smart devices that we all carry, which we know as communication devices. One of the biggest things that the amendments of the 2008 did, they covered all these kinds of devices within the ambit of the law. So today there's nothing digital that's not covered under the IT Act. So if you are providing any services on any of these platforms or on any computer networks, or you use data and information in the electronic form, then lo and behold, you need to tighten your belts. Why? Because you are now going to be covered under this law. Now you said, hold on, I've not heard about this law. And what happens? I don't bother. In India, we'll see it at that point of time. You know, we have the Chalta Hai Maha approach. We will cross the bridge when it comes. Well, you can afford to cross the bridge when it comes, provided you reach up to the bridge. The chances of some potential roadmap hurdles coming are going to be huge. Now, when you actually are providing various services of e-retail on the network, you become in the capacity as an intermediary and in the capacity as a network service provider. And once you do that, you are providing electronic retail services, and you then get fully covered under this law, specifically under 21W of the Act. I think I'd like to just go through this definition to say, now I see a lot of strange expressions on faces of people here. It's more of a shock. You know, I'm talking something which is not good news, but okay, let's see, why is it not good news? This is why it's not good news, because the law has gone ahead and defined intermediary. And let's all read. Intermediary with respect to any particular electronic records is any entity who on behalf of another legal entity either receives, stores or transmits any record, or provides any service with respect to that record, and specifically provides a variety of categories: telecom service providers, network service providers, web hosting companies, online marketplaces, online auction portals, online payment sites, cyber cafes. Now, the moment you are a network service provider, you get classified as an intermediary. Okay? What happens further? If you are an intermediary, then first thing, you are actually provided to a virtual treat. You know, you have this famous saying and a proverb in old of our language, which is said, prior to the disaster comes the scent of something beautiful. When you look at section 79 of the IT Act, you will suddenly feel absolutely rest assured. Why? This is one of the best laws. This is one of the best provisions we could have. And if you are into e-retail, wow, sit back and relax. You have nothing to do. But this is a classical case of legislative deceptive drafting. They draft to deceive. What does it say? It says, notwithstanding anything contained in any other law, but of course subjects to subsection 1 and subsection 2, intermediary shall not be liable for any third-party data, information, or communication link made available or hosted by. Further, you must observe due diligence while you discharge your obligations under the Act. Now, if you don't do that, then you will be responsible. If you do that, good enough, you would not be responsible. Further, you will be responsible if you conspire or abet in the commission of any legal offense. Further, you will also be responsible because once you receive some notice, either from an affected person or by the government, about some illegal or offending content on your network, and you fail to expeditiously remove or disable access to the same, you are going to be held liable. Customer data is critical for your business, right? First thing and foremost, you don't have to go anywhere to protect your customer data. Your customer database is your original literary work, and you have copyright in the same the moment you create it. Now, it will be a different matter altogether that you get some customer base from Nehru Place or whatever and try to use that. That will be problematic, because every time 5 different e-retailers are going to have the same data, they're going to store it in different manners. In any case, the methodology of expression will be different. So the law says the moment you create a database, you have put a small element of ingenuity in the same. The moment you do that, the law is going to protect that, and you will have copyright in your database. If you are still not happy with that, no harm. Just go and take some random sample printouts from your database and file that as part of a database for a copyright application before the Register of Copyrights. It's not going to take you much money. It's very simplistic kind of money, but helps you protect your data, number one. Number two, please be very, very careful when you are dealing with the kind of products. Tomorrow you will not be in a position to argue, I did not know what I was selling. Be sure that you do not become a Sanjay Kumar Kedia. Sanjay Kumar Kedia was one guy who began by selling generic medications on the internet, based out of Calcutta. His business boomed, and then lo and behold, one fine day, the Drug Enforcement Directorate raided him and found that under the garb of these so-called generic medications, he was actually supplying narcotic and psychotropic substances. Now, in that case, right up to Supreme Court, we were not successful in getting bail for the guy, because the Supreme Court said, if you are selling something, you are responsible for what you are selling. You will not have any kind of a luxury to state that I did not know what I was selling, or I did not have any knowledge of what was inside the product that I was selling. More so in the context of use of narcotic and psychotropic substances. So just do your normal due diligence, have your copyrights in place, have your trademarks in place. If you're doing it on any platform, any name, please have it registered as a trademark. It helps you better. And the law is very clear. Don't wait to start business till such time you get a copyright or a trademark. The day you file, your protection begins from that very day. You may get your copyright after 9 months, your trademark after 2 years, not a problem. The day you file your application, your protection begins. Have that protection. Ensure that your systems are adequately well secured. Try as far as possible that your confidential information is not given in the hands of those people whom you will not have any background checks of or whom you don't really trust. Some broad basic due diligence that you would do with respect to retailing in the actual world, the same experience has to be replicated in the real world. Of course, there are no straitjacket formulas. There will be a lot of bumpy rides up and down. But if you are basically able to, as I said, cover your back, the chances of potential problems in the times to come could be relatively reduced to a large extent.